Hello friends, I am Shivaram Reddy. Welcome to my channel. There is a sinister campaign going on against some judges of Constitutional Court, be it High Court or Supreme Court. It's of great concern to note that majesty of the justice is being tarnished by a section of the society. While 5 crore Telugu speaking people are waiting to see a Telugu man becoming the Chief Justice of India, it's unfortunate that Telugu people are trying very hard to show the incumbent in poor light. The recent letters written by Andhra Pradesh Chief Minister to Chief Justice of India S.A. Bobde leveling allegations of impropriety against Justice NV Ramana calls for a closer look. Earlier we have seen Chief Ministers tendering resignation if any court makes any adverse comments or pass strictures. Particularly the stand taken by Andhra Pradesh Chief Minister against the judges of constitutional courts has not come as a surprise, as there was a systematic vilification campaign against the judges for the past 10 years. Let's see what Mr. Ajay Kalam, the Chief Advisor to Andhra Pradesh government, has to say. He addressed a press conference on Saturday, the 10th October, and read out a test letter without taking any questions from the media. Here is what he says.
In larger public interest and in order to put to rest the speculation in a section of media concerning these developments, the government deemed it fit to officially speak on the above to ensure that dignity of all the institutions of the state is preserved. As you are aware, Government of Andhra Pradesh filed SLPs, that is special leave petitions, against the orders of Justice D.V. Somayajalu of High Court staying all further proceedings of the Cabinet Subcommittee and the SIT, and also the order of the Chief Justice Jitendra Kumar Maheshwari, stay of investigation and a gag order on the reportage of FIR filed against the former Advocate General and family members of the sitting judge of the Supreme Court in what is now being referred to as Amaravati land scam. You are all aware of the orders passed by the High Court in this regard. The Government of Andhra Pradesh has apprised the recent happenings in the High Court of AP, in particular reference to the intervention of a sitting Honorable Judge of the Supreme Court, Sri Justice NV Ramana, in the proceedings of the High Court of AP. The government placed the material before the Honorable Chief Justice of India. The instances evidencing Justice NV Ramana's proximity with Mr. Chandrababu Naidu, former Chief Minister, and his interventions to protect the interests of TDP and the party men. The instances of judicial impropriety of Sri Justice NV Ramana while he was the judge of the High Court in combined state in passing orders favoring Mr. Damalapati Srinivas. The government placed material before the Honorable Chief Justice of India about the recent happenings and orders passed by the High Court, which is on account of the direct influence exerted by Sri Justice NV Ramana over the proceedings of the High Court. The government further placed before the Honorable Chief Justice of India recent instances of orders passed by the High Court in connection with Amaravati land scam. Along with this note, the covering letter and the annexures to said letter are being passed on to you. However, from the said annexures, the details of the recent complaint and FIR lodged in connection with the former Advocate General and the family members of the Honorable Judge of the Supreme Court are removed in respectful compliance with the orders passed by the Honorable High Court in writ petition number 16468/2020 dated 15 September 2020. However, all material concerning the said issue have been placed before the Honorable Chief Justice of India. All the above material are placed before the Honorable Chief Justice of India on 8th October 2020 by a covering letter addressed by the Honorable Chief Minister and submitted to the Honorable Chief Justice.
Just now you have heard what Mr. Ajay Kalam, the Chief Advisor to Government of Andhra Pradesh, had said. The dossier is long and needs a thorough probe. However, what is surprising is, if Andhra Pradesh Chief Minister has a case to make out that Justice NV Ramana is acting in a manner prejudicial to the interests of vast majority of people, he being the supremo of a political party, could have moved an impeachment process in Parliament seeking disqualification of the judge. Having fully known that press statements have no legal sanctity, it appears that the statements were only nothing more than a woolly talk at constitutional institutions and lowering the dignity in the minds of the people. In the last 10 years, several attempts were made to question the elevation of Justice NV Ramana to High Court as a judge. An abortive attempt has been made to highlight the fact that Justice NV Ramana did not reveal a case that was pending against him. Wide publicity was given to the issue that the process of selecting Justice NV Ramana was flawed, needs a judicial intervention to annul his appointment. Here, in this background, I am only reminded of one case which was filed against Justice NV Ramana in Supreme Court in 2013, which was dismissed, and the petitioner was fined Rs 50,000 as a cost for taking up a frivolous issue against a sitting judge. Let's see the judgment and some details mentioned in Manohar Reddy versus Union of India judgment, which gave a clean chit to Justice NV Ramana. In Manohar Reddy versus Union of India 2013, the Supreme Court clearly wrote in its judgment that the Attorney General submitted a prayer for a writ of quo warranto, quashing the appointment of respondent number 3, that is Justice NV Ramana, was only a camouflage, and what the petitioners really aimed at was the removal of the judge who had been in office for over 12 years then. The removal of a judge in office, the attorney maintained, it was an issue directly related to the independence of judiciary that's fundamental to the constitutional scheme. The attorney pointed out, in order to make the judiciary independent, to make it possible for the judges to discharge their duties without fear or favor, the Constitution firmly secured the tenure of a judge and granted that the judge of any of the superior courts could only be removed from office on the basis of an impeachment motion passed by the Parliament as provided under Article 124 plus 4 in the case of a judge of the Supreme Court, and Article 217 read with Article 124(4) in the case of a judge of the High Court. The Constitution did not recognize any other mode for the removal of judge. Any deviation from the constitutional process in the garb of quashing the appointment by a writ of quo warranto would be violative of the scheme of the Constitution and deleterious for the independence of the judiciary. The Attorney General further submitted that if the petitioners thought that the appointment of respondent number 3 as a judge of the Andhra Pradesh High Court was wrong and there were grounds for his removal from the office, they could always bring the matter to the notice of the Parliament, which alone was the constitutional forum competent to remove a judge of the High Court from his office from any misbehavior committed either before or after his appointment as a judge. The Attorney General added that in case the Parliament declined to take any action for the removal of the judge on the petitioner's complaint, the court was powerless in the matter and the removal of the judge could not be brought about by the device of quashing his appointment. The Attorney General went so far as to say that in entertaining this writ petition on merits, the court would be overstepping its constitutional limits. How Justice NV Ramana got appointed as High Court Judge? The Supreme Court judgment in Manohar Reddy versus Union of India recalled that the name of respondent number 3, that is Justice NV Ramana, was recommended for appointment as a judge of the Andhra Pradesh High Court on November 14, 1998 by the Chief Justice of the High Court, with the other 2 collegium members agreeing with the recommendation. The recommendation made by the High Court was received in the Supreme Court on February 15, 1999. At that time, the age of respondent number 3 was 41 years and 6 months, and he had completed over 15 years of legal practice. In the resume prepared by the Ministry of Law and Justice that came to be put up before the Supreme Court Collegium, respondent number 3 was described as Sri NV Ramana Advocate, was enrolled as an advocate on February 10, 1983. He has practiced in the High Court of Andhra Pradesh, Central and Andhra Pradesh Administrative Tribunals and the Supreme Court of India in civil, criminal, constitutional, labor, service and election matters. He has specialized in constitutional, criminal, service and interstate river laws. He has handled about 800 cases during the last 3 years. He has functioned as panel counsel for Andhra Bank, Vaishya Bank, United India Insurance Company and Food Corporation of India. He has also functioned as additional standing counsel for central government and standing counsel for railways in the Central Administrative Tribunal at Hyderabad. And the Intelligence Bureau report about Justice Ramana stated as Justice Ramana enjoys good personal and professional image. Nothing adverse against his character, reputation and integrity has come to notice so far. He has also not come to notice for links with any political party or communal organization. None of his relatives is either serving or has served earlier as judge in any High Court or Supreme Court. Following the consultative processes between the different constitutional functionaries, a notification was issued on June 19, 2000, appointing respondent number 3, that is Justice NV Ramana, as judge of the Andhra Pradesh High Court, and he took the oath and assumed the office as a judge of Andhra Pradesh High Court on June 27, 2000. Since then, he is continuously working in that capacity. A section of the society has been highlighting the fact that elevation of Justice NV Ramana was not proper, as he did not disclose a pending case against him. This was discussed elaborately in M. Manohar Reddy versus Union of India case. Here is an extract of the judgment. It now comes to light that all through the period when the recommendation was made for his appointment as a judge, the notification was issued and he assumed the office as a judge. A criminal case was pending in which respondent number 3 was an accused. It's therefore necessary to look into the criminal case and its proceedings. The judgment continues, stating that the criminal case in question dates back to the year 1981, when respondent number 3 was a student of Nagarjuna University. The students of the university, it appears, complained of inadequate public transport facilities for commuting from their homes to the university, as only a few buses plying between Guntur and Vijayawada stopped at the university. The students demanded that more buses should stop at the university. As is not uncommon with the youth in this country, some of the students of the university took to agitation in connection with the demand at about 8:30 p.m. on February 13, 1981. A group of about 30 students put roadblocks on the GNT road opposite Nagarjuna University, causing stoppage of all vehicles on the road. At about 9:15 p.m., a bus of the State Transport Corporation on its way from Guntur to Vijayawada arrived there when there was already a heavy jam and pulled up at the road flank. In such situations, unfortunately, a state bus is the softest and the most vulnerable target. In this case also, the state bus became the target of the agitating students' ire. The driver of the bus was pulled down. The door to the driver's seat was damaged. Some miscreants pelted stones on the bus and smashed its windscreen and glass windows with iron rods. One of the passengers also received some injuries. By this time, a police party also came to the spot. At this stage, an attempt was made to set fire to the bus by throwing a burning oil cloth tied to a rod inside the bus. But a policeman put out the burning cloth and the bus was saved from any further damage. Shortly thereafter, the police dispersed the agitating students and restored normalcy. On the same day at 11 p.m., the driver of the bus lodged a first information report in connection with the incident at Mangalagiri police station, where it was registered as crime number 55 of 1981 and sections 147, 342, 427 and 324 of the Penal Code. The first information report was against unknown persons and the accused were described as Nagarjuna University students. The police, after investigation, drew up a charge sheet dated October 10, 1983, and on October 19, 1983 submitted it in the court of the Municipal Magistrate Mangalgiri, where it was registered as CC number 229 of 1983. From the charge sheet it appears that in the statements recorded under section 161 of the Code of Criminal Procedure, the driver and the conductor of the bus, apart from some other witnesses, identified and named 5 persons as the student leaders who were leading the agitation on February 13, 1981. The charge sheet accordingly cited 5 persons as accused and respondent number 3 figured among them at serial number 4. All the accused were shown as absconders. The charge sheet, however, does not disclose what steps were taken by the investigating officer to secure the presence of the accused. There is no mention that the investigating officer ever tried to obtain from the court warrants of arrest or processes under sections 82 and 83 of the Code of Criminal Procedure for apprehending the accused. They are simply shown as absconders without observing the procedure sanctioned by law before an accused can be called an absconder. The case was dismissed by the Supreme Court and it gave the Justice NV Ramana a clean sheet. In conclusion, the common man was at a loss of words. So what's the real intention of the Andhra Pradesh Chief Minister writing a letter to Chief Justice against the second most senior judge of Supreme Court of India? Where will it lead to? the judgment is not in favor of one party. The easiest thing is to call the judge's names and obfuscate the real issue. Judicial activism is the need of the hour. People occupying high places must exercise restraint and be a model unto others. Painting all with one brush is myopic and short-sighted and would have deleterious consequences. An atmosphere of fair play is needed. As the old saying goes, it's not only that justice must be delivered, but must be seen and appear that it should have been done. On this optimistic note, I am Sivarama Reddy signing off. Thank you.